This is a big day at the trial of George Zimmerman. After 12 days of testimony, closing arguments are set to begin. NBC's Kerry Sanders is in Sanford again for us. Kerry, good morning.
Good morning, Savannah. Closing arguments indeed set for this afternoon, and everything follows the judge's schedule. The case could be in the jury's hands as early as tomorrow.
Defense would rest.
After 56 witnesses and 12 days of testimony, both sides have rested. The accused, George Zimmerman, will not take the stand in his own defense.
Mr. Zimmerman, please stand up. Is it your decision to not testify in this case?
Yes, Your Honor.
In court Wednesday, the defense called their final witnesses, among them Dennis Root, an expert on the use of force. He was asked if Zimmerman had any other options but to shoot 17-year-old Trayvon Martin.
I don't know what else he could have done based on his abilities, because, not to be offensive to Mr. Zimmerman, but he doesn't seem to have any.
Zimmerman is charged with second-degree murder in the shooting of Trayvon Martin, but maintains it was self-defense. He's pled not guilty. Also Wednesday, prosecutors brought out a life-sized foam mannequin.
Does it appear to be anatomically correct?
And asked Dennis Root about what may have happened just before the shooting.
Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that. No, sir.
Okay, well, where would the gun be now?
Now the gun would be behind your left leg.
Zimmerman's lawyer used the same mannequin to demonstrate other ways the attack may have happened.
Could it happen this way?
Yes.
Same mannequin. Could it happen this way?
Yes.
Could it happen if Mr. Martin is reaching back with his hand for yet the final strike or something like that? Could it happen right there when he's coming back over?
As long as the alignments of the body stay within those same relative positions, where they are within that axis of movement, it's a possibility.
Each side has been given 3 hours for its closing arguments. The state will use 2 hours today. Then tomorrow, the defense will use its 3 hours. The remaining hour that the state has will then be used, and the prosecutors will give the jury the last word. Savannah?
Kerry Sanders, as the trial is wrapping up, thank you. Lisa Bloom is today's legal analyst. John Q. Kelly, a former prosecutor. Good morning to both of you.
Good morning.
First question I want to ask has to do with the legal decision that the judge will make this morning, and I think it could be incredibly consequential. Whether or not jurors will be given the option to convict of a lesser charge than second-degree murder, whether they'll be given a manslaughter instruction. Sure. The defense has said, we don't want it. Basically, it's all or nothing. Is that smart, John?
I think it is. There's no way the prosecution has demonstrated a depraved mind or ill will on their part, and the evidence would support a manslaughter charge, at least, if not a conviction.
So the defense is saying we're afraid the jurors will compromise, that the prosecutors haven't proven the top charge, and if we give them the option, they might compromise.
It shows the defense has a lot of confidence in their case. They're willing to take the all or nothing risk, either life in prison or George Zimmerman walks.
Meantime, let's show you a piece of tape that came from yesterday. The judge and one of the defense attorneys getting into it. Take a look.
I am asking your client questions, please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your objection is overruled.
Lisa, tell us about that, because basically the judge was asking George Zimmerman, do you plan to testify? This happens all the time in trials, but what was the issue here?
You know what doesn't happen is an attorney objecting to the judge's question. You object to the other side. I think what the defense attorney was expecting was 2 more witnesses later that this was going to happen, and they were just caught off guard.
So that basically the defense attorney felt the judge was rushing him too much.
The judge was a little bit out of line. She should have addressed it to counsel, not the defendant at that point.
Okay, well, look, they're going to get 3 hours to make their closing arguments each side. I'm going to give you each 30 seconds. How does that sound? John, I'll let you be the prosecutor. What is the strongest evidence, the strongest argument you can make for a second-degree murder charge?
Mr. Zimmerman initiated unprovoked attack or confrontation with Mr. Martin after being told not to follow him. He brought the instrumentality of death, the loaded 9mm, to that confrontation. And the only person that would have been screaming for their life on that tape would have been the 17-year-old that had a gun pulled on him unexpectedly, not the grown man who had the loaded gun.
All right, Lisa Bloom, you're the defense attorney.
Check your politics at the door. This is a criminal trial, and it's only about the evidence. George Zimmerman has always behaved like a reasonable man, fully cooperating with the police from the beginning, answering every question on audio tape and videotape, telling a consistent story. The best witness in the case, John Good, a neighbor who didn't know anybody in the case, who said in the final moments before that shot rang out, Zimmerman is down. Trayvon Martin is over him. Pound and ground MMA style assaulting him. He took out the gun, which he had a legal right to carry, shot once in self-defense. It's a reasonable doubt case.
Okay, I'll give you 5 seconds to answer. If you could pick either side to be on right now, who would you rather be?
I'd pick the prosecution side, even though you asked me to do the defense collision.
What about you, John?
Prosecution on the lesser included charge of manslaughter.
All right, Lisa Bloom, John Q. Kelly, great to get your perspectives. Thank you.